My lord, first of the judgment is 2024. (2024) 14 SCC, page 225.
Yes.
Yes. My lord, paragraph 13 may kindly be seen at ink page 5. Apart from the power to grant maintenance, the tribunal exercises important jurisdiction under section 23 of the 2007 Act, which reads thus: where any senior citizen who, after the commencement of this Act, has transferred by way of gift or otherwise his property, subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor, and such transferee refuses or fails to provide such amenities and physical needs, the said transfer of property shall be deemed to have been made by fraud or coercion or under undue influence, shall at the option of the transferor be declared void by the tribunal. Where any senior citizen has a right to receive maintenance out of an estate and such estate or part thereof is transferred, the right to receive maintenance may be enforced against the transferee if the transferee has notice of the right, or if the transferee will. The transfer must have been made subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transfer. And thereafter, my lord, this division bench holds, it is very painful to say no, but still constrained to follow this.
So we have said, so there are subsequent decisions which we have followed.
My lord, the subsequent,
if I'm not mistaken, this bench has passed a judgment.
My lord, the subsequent decision also does not deviate from these two twin conditions.
Where does it say expressly stated in the agreement? In the settlement deed or the gift deed? There's no express requirements.
My lord, there is no express requirement, and it is not stated in the settlement deed that they should be.
Therefore, there is no requirement that it should be expressly stated. It only has to be established.
My lord, it is, if it is to be
conduct, it can be established by sequence of events. It can be established by any number of ways. It doesn't have to be stated expressly.
My lord, what they say is fraud. Fraud has to, there is a judgment of
deemed fraud.
All right, my lord.
Not fraud, it is deemed to be fraud. If you don't do it,
and in this case, the pleading is to the effect that they are looked after. They are looked after by the daughter, that second appellant.
Where?
That I have stated so in the statement of objection.
They have to state. You can't say you're looking after. They have to state that.
My lord, any time, that is what, any time they were living with the appellant number 2. They were living with the appellant number 2.
This is a registered document. The settlement is a registered document.
Yes, my lord. Settlement need to be registered.
Where?
My lord, it was registered in the office of Sub-Registrar Brahmapura, my lord. That, my lord, in Kannada version at page 91, it could be seen in the on the second page of it at 92, page 92. All this, my lord, if I am permitted to make my submission, is at the instigation of the brother of the second appellant, who also got a property and had an eye on this, and various suits have been filed. There is a development agreement in respect of the other properties, wherein respondent number 1 is a partner, and she derives the income, but that is not an excuse. I am placing it before the court on the face of this matter. And the statement by the appellant even now.
See, this is not even, the pleadings in this case are not even,
My lord, my lord, this
not even deemed. They're saying effectively you got signatures done, which you didn't know what document she was signing.
no, it is not in dispute, my lord. That is
That's their case. That's their petition.
my lord, the petition before the, I have a copy, of course, it copy of the complaint before the tribunal.
Yes.
That what they say is blindly they have signed it.
They don't know what they've signed. That's what they're saying.
And in one breath, it is stated before the tribunal that these petitioners do not admit the truth, validity, genuineness, and binding nature of the said alleged document, settlement deed. Then there is a suit pending.
Where is the suit pending?
My lord, the suit, I shall give the details, my lord, because it is bulky document. It is part of the document before the Deputy Commissioner also. I shall place it before this honorable court.
Get the suit. Let's see what suit is that. Just bring it tomorrow.
Please, my lord.
Bring it tomorrow, the copy of the suit.
My lord, within a week, all the copies with the translated.
All right.
Yes.
Next week. Next week.
On 12th of March.
Please.
Number 10.
I appear for the complainant, my lord. My lord, we had filed rejoinder for the statement of compliance, my lord. There appears to be some office objections. We'll comply the office objections, my lord.
They've already sold the project, my lords, and even before, my lords, the learned single judge had not disclosed the fact that the project was sold by them.
Yes?
They had already sold the project much earlier to approaching the learned single judge.
My lord, we had filed the rejoinder for the same objections, my lord.
The order, my lords,
Complied the office objections,
the subsequent purchaser of the project comes to us, my lords, and says, my lords, that they have brought the project and we should not entertain them. That, my lords, would find it at annexure R1, my lords, page number 3 onwards from my statement of my affidavit that I have filed.
No, but then that is up to between them.
They have filed a suit also, my lords.
That's all right. If they've got a stay order, that's it. Then it's all right.
Look, we have issued a necessary endorsement that the roadbed does not entitle them for the FAR.
What?
The FAR, what they are seeking. That they are not.
The directions are to issue a modified building plan with FAR
Please.
2.5.
Please, my lords, but that FAR cannot be considered for the reason there is no road width available.
There is no.
The road width available. That order of the learned
That
citizens.
story is over. No, that's what
But
you're
we have
arguing.
challenged, my lords, independently in the writ appeal. My writ appeal is there.
You show this one.
My writ appeal, please, my lords, is, I'll pass on, please, my lords, the number to the court officer, my lord. That could be clubbed on with this.
It's 2023. When is your writ appeal?
The same year, my lord, we have filed the writ appeal also. Challenging the
Writ
order of
appeal
the
was-
learned single judge. That was in office objection stage. That some objections had to be clarified because many of the papers, my lords, in the writ petition, we bought Xerox copies, we had, my lords, we had filed it, my lords. So some, or,
There is lying in objections from 2023.
my lord,
please,
it is
my lord.
dismissed because of
So go, it should be
non-compliance.
dismissed automatically. What?
Please, my lords, but what transpires is I don't have the original records, please, my lords, to make a copy of that, to place it before my lords. My lords may give me some time in that, my lords. I file necessary application to restore it to file. For the reason, my lords, that I'm in trouble.
You
Please,
have
my
a petition of 2024.
Please.
Order of 2024.
we have filed the necessary writ appeal, please, my lords, much earlier, and in time.
There is
but-
no filing. You just lodged it somewhere.
No, my lords,
There effectively no filing.
My lord, the writ appeal was
Like the rule
dismissed
should
for.
be amended. In 30 days, you don't clear objection, should automatically be
Lords, I have shared the objection. They have filed rejoinder to that is what they're trying to say.
rejoinder to this.
Please, my lords, my objections. My-
Rejoinder to your objection
Please,
is a
ma'am.
separate issue.
Please, my lords.
We are, you saying you filed a writ appeal.
Writ appeal we have filed, my lords.
You've not got a stay order.
We have not got, because now that office objection stage, my lords, it was dismissed for the reason, my lords, I could not comply with the office
Your
objection.
writ appeal is dismissed.
Please, my lord. But I have filed
And
application.
this order you have to comply with.
Please, my lord. My respectful submission is, my lords may tag, but I have filed a restoration application in my writ appeal. If my lords could tag this with this writ, this contempt.
It's a dismissed appeal. We are not tagging a dismissed appeal. to this thing.
My prayer to
answer-
my lords is my lords could
Please
restore that.
answer. This is a valid order. How can you not deny him? On what ground will you deny him?
Lords, the first ground is, my lords, that he has already sold the project long earlier to having approached.
That's not, they're not,
Let's-
there's
the
no
third-
stay order. He has made an application. You are asked to give him the, you can't now give an endorsement. I will not give it.
No, my lords, I have said, my lords, that there is no road width also available for me to consider the application.
That's not available to you. No?
If there is no road width, my lords, in front of the
You see
property.
the order. Para 12.
Lords, they relied upon a certificate issued by the then assistant executive engineer. For what purpose it was issued, we don't know. But we went subsequently, we checked, please, my lords, that there is no road width available.
You can file a review, you can file an appeal, none of which you filed. The order is final.
Appeal
You
has,
can't sit in your office and ignore it.
please, my lords, I have filed necessary application also, my lords.
Whatever
seeking
your
for
necessary
restoration.
application is, you frame charges and put you to trial.
Lords, my lords may give me a one date, my lords, I will.
Not necessary.
Lords, I will.
They have a writ petition. The issues you don't raise. You get an order against you. Then you sleep in your office. You don't file. You file your writ appeal, which is dismissed. No review is filed. And then you give an endorsement that you will not follow this
I
order.
filed, my lords, the application for recalling my order, that order for
When you-
dismissal.
If this order is set aside or stayed, we will stay our hand till then you face your trial. And if it's convicted, you should effectively take action. For
Lords, my lords may-
one matter, you will multiply it by four petitions. Now a contempt, a writ appeal which is dismissed, and your review which will follow.
No, well, we will not file the review, my lords. We have filed a writ appeal, my lords. I have filed a necessary application. My lords may give my.
The king shall be present to court. There is no ambiguity in the complainant has filed the present complaint alleging willful disobedience of the order dated 3rd January 2024. The operative part of the order reads as under. There is the learned Admittedly, the directions have not been complied with, as much as a modified building plan oblique license with FAR of 2.5 has not been issued. Learned counsel appearing for BBMP submits that it has not been issued as because the width of the road is not 18.4 meters. So this was one of the issues that was considered by the court in its order dated 3rd January 2024, the disobedience of which is alleged. Full stop. Although it is stated that an appeal had been filed against the said order, the same has also been dismissed as the office objections have not been complied with. Full stop. Notwithstanding that there is the order. Has declined to implement it and has issued an endorsement, raising also an issue that the subject property has been sold. Dispute regarding that is pending. However, there is no stay order. There is no order interdicting the accused from complying with the order that has been issued, which either directly or indirectly interdicts the full stop. Does prima facie appear that in view of the above, it does prima facie appear that the accused has acted in disregard of the orders passed by the, as willfully disregarded the orders of this court. And the accused is present here for framing of charges. This term, written in April.
So 16th March. Number 11.
Complaint done.
The impugned order came to be passed on 14th August 2024.
Lords, we had the contention. The contention, my lords, of the complaint was that of the 38 guntas of land belonging to him, 36 guntas was acquired for the Nadaprabhu Kempegowda layout, and the other balance 2 guntas was used without any acquisition. And a representation to that effect was given, my lords. Now we have considered that and we have informed that 2 guntas has been used for the formation of PRR.
You have an endorsement.
As per the endorsement, they are agreed to award the compensation in respect of old.
Doesn't matter. Your order is
Yes,
only.
as on that, they have not made any payment also. The order came to in their 2024 itself.
No, the
Now
order,
they are, yes, my lord,
the order is what?
to pass an award in respect of 2 guntas of land.
To consider your representation.
Yes, please.
They have considered giving you an endorsement. The complainant has filed the present complaint alleging willful disobedience of the order dated 14th August 2024.